There you go. Good evening, everybody, and welcome to Spin Legal. It is January the 29th, 2025. I was going to say 26 there. Episode number 51. With Angela and myself, we are partners at Invictus Legal. And tonight, our topic is a no-fault eviction. And the difference between an N12 and an N13, what the laws are around that, okay?
What your rights are, whether you're a landlord or what your rights are as a tenant.
Yeah. Yeah, and it's important to know those sort of things because we at the beginning I said a no-fault eviction, right?
Mm-hmm.
Right. So there we go. Okay, so if you need to contact us at Invictus, you can do so at 905-688-5598. Email Angela at weareinvictus, or myself at Peter at weareinvictus.legal, and our website is weareinvictus.legal. There you go. Okay. So, as I said, today we're talking about these no-fault evictions, and especially what the difference is between an N12 and an N13. So probably the best thing is to start with some definitions.
Okay, an N12 and an N13, these are two types of notices that are created by the Landlord and Tenant Board to be issued to a tenant, by a landlord, with respect to certain reasons why a landlord may want their property back. And there's different reasons for each of these forms. And the description is on the forms themselves.
And you better use them for the right reason and be the right person involved, because what the difference is matters. An N12 is for yourself or a member of the family moving in.
Yeah. You can't just say my brother's moving in or my best friend from kindergarten is moving in.
Yeah, and who the heck is your best friend from kindergarten, and how come you haven't known them ever since then? Yeah,
exactly. And these are things that you have to be very, very careful about. There has been a lot of things around that. Like sometimes you'll say my son's moving in, and it turns out that they don't have a son. Or maybe they're adopting one.
The closest they ever had to a son was when the wife had a miscarriage in 1969.
Yeah.
that kind of thing, you know.
Yeah, there's a lot of stuff out there, and we have to be very, very careful. Things have to be done to the letter of the law. If the landlord is going to exercise their right to take the property back, in either of these cases.
And the N13, and the N13 so that people know that's about renovations. So,
renovations, like when you're putting things down to the stud, literally, and redoing the apartment. The other one is demolition. You're tearing down the building. And the third one is conversion. You're converting the building for another purpose.
Yep.
No longer residential purposes. I had to deal with that one time. There was a fellow in there was a 12-unit building, and the landlord picked his unit specifically to become an office for the landlord and to store maintenance supplies. So I remember fighting that one. Why his unit?
There was one of those in the LTB about a year ago, and the line of questioning was, well, why apartment 1? Why not apartment 2, 3, 4, 5, 6, 7, 8, 9, or even 19, 20, 21, 22?
Yeah, exactly. Like the more apartments or units you have in the building, the more that can be left to question.
Yeah.
The renovation thing, I can sort of understand. If you have an older building, I can understand you're going to have to go in there sooner or later, and you're going to have to tear the down thing to the studs. But remember, there's a lot of steps that you have to take. And these things are legal steps that you have to follow.
Yeah, exactly. We'll get to those.
Okay.
We'll get to those, all right, as we go through them. So we've got then an N12 is being issued because a member of the family or a carer for a member of the family is going to be moving into that unit.
Yep.
And, So the question here is, what then should a landlord do?
Because the landlord, this is where you have to be very careful. They have members of families that are identified on the form, okay, with respect to who moves in.
Yeah. And it's only those that are identified
only
on the
those
form.
people can be identified. I remember a person tried to move their grandchild in.
Yeah.
And they got shot down.
The other one that I've heard is the tenant came to us a few months back, if you remember, the one who said they're trying to move their cousin in.
Oh yeah. Yeah, their cousin from Palestine.
Yeah, that was the one. Yeah, Palestine.
Yeah, and I said, although I empathize with the situation there, but you can't use an N12 to do that.
Yeah, exactly. And so it's important that you do the right thing. Family members is basically, you can't even do, I couldn't even say, hey, Angela, I'm sorry, bye-bye. I'm moving my brother in.
Nope, right? Can't be a brother or sister or a 53rd cousin.
Yeah, so it can be my parents. I don't have any. they are died and gone. So
you don't have them in an urn somewhere, right? That you can move into urns.
I do not have them in an urn anywhere. No. And furthermore, my father believed in a woodland burial, so urns were not a part of the family tradition, right?
Yeah.
So yeah, I could move my son in. An interesting thing is, for example, I could move my son in, or you could move your son or daughter in, right? Yeah. But what would happen if, for example, your son's been married, let's say, and they've got children, and let's say this thing happens, that your son and your daughter-in-law have split up, but you're still close to your daughter-in-law, and you want to move your daughter-in-law in. That's a big fat no-no, isn't it?
Mm-hmm. I don't think the son would be very happy with that.
Well, quite apart from what the son thinks, the landlord and tenant board would be saying, oh no, she's not on the list.
Yeah, it doesn't happen. It isn't going to happen.
Yeah. It has the son could move in with his children, but his ex-wife could not move in with his children. Right? And
yeah,
there have to be limits to these things. And the other question is, so it's parents or children, right? Or spouses, parents or children. Right?
Yeah. Like you can have a spouse. Sometimes spouses or your spouse, sometimes spouses live in 2 separate units or, for work purposes or some reason. Hey, then you'll have your spouse move into that unit while the other spouse works, say, if they have to work in Ottawa or something.
Yep.
And then that spouse will be moving into that rental property.
Yep.
Right? So, I mean, these things happen. I've had to defend a case like that, hey, because somebody said, oh, they split up for convenience. Hey, no, they didn't. They didn't want to be split up like that.
Actually, that is one thing whereby, I guess, a divorce, a spouse, if you said spouse, you would that survive a divorce?
I would presume it would. It's kind of hard to tell, if there is a divorce, I suppose the landlord can start taking some action and saying, I'm moving in now.
Well, no, but again, spouse may well be moving in, or
But that's an interesting question. That's an interesting question.
It's not one that I've seen at the board.
Yeah, I haven't seen that yet, but I'm sure that it'll be walking in our door at any time.
The other one here is carers for your family. So that may well be that, hey, I'm an old man now. I'm 85 and I need a carer. So
I have one right now that I'm working on. The landlord is an older gentleman. He's worked all his life with his hands, and he's operated a farm for many years. He's got many health issues, and niece and nephew, they've been looking after him for years. So he's taking a unit, and the niece and nephew are taking another unit.
Yeah.
Okay, to help them out because they have, so it'll be in the same place so that they'll have access to them, be able to drive them places or whatever they need to do. Right. So I mean that's perfectly legitimate.
Yeah. Yeah,
Right?
but you're not talking about here the niece. The niece and nephew is an irrelevant.
Yeah, it doesn't matter who they are to you.
Yeah.
They have to be caregivers. They have to be providing care to you as for personal service that you couldn't get elsewhere.
Yeah, and that carer could be
a family member, or it could be somebody from an agency, or it could be just somebody you pick up and you make a friend, and they happen to be someone who can look after you.
Yeah.
For a while, and that happens. And
it could be a PSW care worker who is assigned to 24/7 look after you. That type.
That's becoming more and more common because people want to age in place.
Yeah.
Okay? They don't all want to be shipped off to nursing homes.
Yeah.
Like, who wants to be shipped off to a nursing home? I bet you if I ran a poll here, I'd probably find like 99.9999% of people don't want to be shipped off to a nursing home. So that's why these things are happening, so that people can have aging in place.
Yeah, and the rules about carers. The carer is actually again for the parent, for the children, or for yourself.
Yeah, exactly. It has to be a family member carer. Yeah.
Yeah.
Hey, not, and it can't be like this one looks after my 53rd cousin. No. Yeah. It has to be for your child or your parents. Yeah. And again, elders, that's very important too. You might have elders and provide an apartment for your elders, and then another apartment could be for their caregiver.
Yeah. And actually so the caregiver, there's not necessary that the caregiver is exclusive, is it?
No.
Right. It's just that the main care they give, the main person they give the care to is actually the person who is in the rental the other rental unit, close by rental unit.
Yeah. So if you own the rental unit, you decide to move in, but you need to have someone help you out, drive you places. That person will be moving in because they're caring for you, and they're your primary.
Okay, another one. I've always run this. through my company. I'm really the landlord, but I run it through my company just in case I get sued, because it's much better to have 1, 2, 3 irrelevant company limited sued for $1 million than it is for me to be sued for $1 million.
And you're giving an N12 on behalf of the company? Forget it.
Well, no, it's not the company.
I got a minute book in here somewhere. I've got a minute book in here somewhere. Do we put that minute book inside the unit or what?
No, it's my property. It's my property. My company's. I'm just use that as a tax write-off.
Can't do it. You can't be a corporate. It can't be a corporate landlord. It has to be a personal landlord.
Yeah, and that's an important factor here. That only applies to an N12, but all of the things that are at the board, it could not possibly be a corporate entity. So if a corporation owns the property and you want to move a person in there, you're going to have to rethink that relationship.
Yep, exactly. It's like your company, like, I've got a minute book in here somewhere. So you're going to be moving the minute book in there?
Yeah. And the minute book's got an office as well, and the bedroom.
Minute book's got an office. You can move office. You can vote and pass a resolution to change the head office. There it is.
Yeah. Yeah. So it's very important that you actually know and use that correctly, right? So it is only for family and carers, and the owner must be a living person, not a corporation.
Yep. And you also have to make sure that that it is the landlord, or the spouse, that's going to be moving in. The person who is giving the N4, it can't be like a friend of the landlord or speaking like on behalf, like not a legal agent, but somebody who might be their cousin or their son of the landlord. Well, the son of the landlord can move in, but the landlord is the one that has to be serving the notice.
Yeah.
saying that my son's moving in, and then the son does a declaration and saying why he needs a place.
And that declaration is quite important. I've been on the tenant side of a number of cases where no declaration has occurred. The family has moved in, there's been no declaration, or the buyer has moved in. And that's actually something we just didn't cover. The buyer.
Purchaser.
Yeah.
Yeah.
Right.
See, for family members moving in, they have to move in for at least 1 year, for a 1 year period, and have that plan. And it has to be stated in the declaration. If it's a purchaser, the purchaser must move in for a reasonable period of time and to be in that place for residential purposes. It doesn't say the length of time, but they can't just move in like for 2 weeks and then move out.
Yeah, and in fact, actually, that was one of the factors in a case that I recently handled for a tenant. The purchaser bought it, stated they were moving in. In fact, never put in a declaration that they were moving in, but in amongst their evidence that they put forward was the words, to the seller, the purchaser will be using it for investment purposes.
Whoa. Ding, ding, ding. That was when they opened their mouth.
Yeah. At a point whereby I know the tenant didn't see that evidence until the actual day of the hearing, but it is evidence that can be used against the landlord.
And that's what we found. One of the landlord's or purchaser's representatives, they included that in their evidence package.
Yep.
And this is what you have to always be aware of what they're doing. And generally, they do have to disclose everything, including something like that could be used against you. And if you can defend it, maybe defend it, right? But but you have to make sure you dot your I's, cross your T's.
Yeah. Okay. So, as I said, so those 3 areas that can be used, that's for somebody who's buying the property, yourself or your spouse or your children or parents, or carers of yourself, your spouse, your children or your parents.
Yeah.
And that's the only times at which an N12 can be used.
Yeah.
Right?
They used to be abused quite a bit. Hey, I just want this tenant out badly, so I'll just hand out an N12. Hey, and it doesn't work anymore.
Yeah. And the rules have become quite tight, and the LTB have become quite, they've been looking at this quite, quite hard, and they're making decisions against landlords that don't do the right things.
Yeah. You've seen places where they said that they're going to be moving back into the unit, then all of a sudden the place is for sale.
Okay. So if we're going to ask this, what should a tenant do if they're in that situation? They've just been given an N12, and assume for a moment. Well, the first thing we always do is actually, is the N12 valid?
Yeah.
Right. And assume for the moment the N12 is not valid. If the N12 is not valid, typically what we would do is we'll say, okay, there's an error in the N12. We'll let the hearing come along, and we won't educate the landlord about the error in the N12.
I had a landlord do that twice in a row. They made a mess of the N12. They made an error that was a fatal error both times. And the second time she says, "Oh my God, what do I have to do? How many more months do I have to wait?" Well, the thing was, first she said that she was going to be renovating the building. Then she was going to have her son move in. And then she was going to say her daughter was moving in. Like, I just asked her, what are you going to do with the building? I need to know.
Yeah, exactly. So those kind of things can play against the landlord when it comes down to the hearing. So come on, Mr. Tenant. Yeah. What you should do is you should basically, first of all, you need to look at it. Are the dates correct? And there's a set
And we
rule.
can tell you, like, you should bring the N12 into a legal office, ask them to look at it to make sure it is correct on its face.
Yeah.
Okay. Make sure the address is correct, make sure the dates are correct, the notice period is correct, and so forth.
And that actually brings up another interesting point, the address, right? Probably the best source of addresses in Ontario is the Landlord and Tenant Board, because they know every unit that there is in the province, I think.
Like, isn't that interesting? They send a 110-page evidence package that they must have worked all night on and all day on, and they send it to you, and then the address forgets that it's a duplex, and they didn't include the part of the duplex that the application is about.
Oh yeah,
that's going to be tossed.
Yeah, exactly.
It happens.
That happens. It happened. I got it tossed. They've been waiting for 10 months for a hearing, and within 5 minutes it's gone. Sorry, Mr. Jones, you didn't do the right thing.
Yeah, and these are things you have to be really, really careful about if you're putting this across. And even then, as a tenant, that these N12s, even if they're correct on their face, we need to look at the reasoning, who's moving in, and is it realistic?
Yeah.
Okay. Like, if somebody's staying in China, or they're working in China all the time, and they have a full-time job in China, and they're a head researcher at the Wuhan virology lab or something, right? He's studying COVID viruses or something. And the thing is, they're not going to come down here. They're not going to be living here.
Had that job for 53 years. They're not going to be moving to.
Yeah, exactly.
Yeah.
Or if they live in a 12-bedroom house in Scarborough with a mansion, and they have a whole part of the house to themselves, they're certainly not going to be moving into a bachelor unit in Hamilton.
Yeah, exactly.
Right? So there's a lot of realistic things that this kind of
just knowing a bit about
scratch their head.
Yeah, just knowing a bit about your landlord or the people they're intending to move in. For example, if a landlord lives in, I don't know, let's call it Richmond Hill, for example, lives in Richmond Hill. He's got a $5 million mansion, but he's got an apartment.
He's got a great job in Richmond Hill.
But he has an apartment in Welland, and his excuse is that my son is going to Niagara College in Welland, and I want my son to move in there. There might be some viability in that.
There might be. We'd like to know about the program that the son is taking.
Yes, exactly.
We'd like to know about how he's going to be living there, and is there any alternatives? Does the landlord have an alternative accommodation? We do search. We do search on Terranet to see if the guy's got 15 houses in Welland. Okay.
That is the other question, of course. And I did the search on Terranet the other time and turned up 6 alternative addresses in the Niagara, in North and South Niagara, let alone how many he might have in Haldimand County and Hamilton, for example, let alone how many you might have in Richmond Hill, etc. But for example, the college address, that excuse, when there's a dozen other units in the near proximity, that starts to weaken that whole argument, doesn't it?
So there's a lot of things like that. You have to be kind of reason why that unit, right? So maybe it's right across the street from Niagara College, and all the other ones are way, way, way at the other side of Welland. Maybe that's the reason.
That may well be fair.
Yeah.
And that would be for an adjudicator. I would say that is an argument for an adjudicator to hear.
Yeah.
Right.
So these are things that you have to think about as a landlord who's doing these things. Get a legal representative to help you with this, because all of these things are questioned. More and more tenants are challenging them, even for the sake of challenging them. Okay. So the thing is, we have to be very careful, dot the I's and cross the T's.
And aside from anything else, the purpose of challenging something like an N12 from a tenant's perspective is maybe I can live there for another 8 months, 9 months.
Yeah, and it gives the tenant some time. Sometimes that's all they need.
And another
time to be negotiated.
Another factor.
And it turns out that the landlord is right, that somebody's moving in, so forth. Maybe negotiate some time.
Yeah.
Let's wait till September when the son really does need to move to college.
Yeah. The other question about this is compensation.
Yeah.
Right?
Compensation is another one.
Yeah.
So you may want to top it off a bit.
Was compensation paid? Normally, the most direct way to pay compensation is a check.
Yep, just cut a check for the amount of compensation that you owe, and it has to be given on or before the termination date.
Yeah. Right. Now,
and tenants refusing compensation. This happens because sometimes the tenants want to challenge that and say they weren't given. Okay, the best way to do it is try an email transfer. Okay, or try to give it through some other means where you can prove that you tried to give it to them.
Well, and refusing it doesn't invalidate the payment of the money.
Right, exactly. So if the tenant didn't pick up the email transfer, for example, it doesn't mean that they were not given compensation. It just means that they did not pick up the email transfer, and the compensation argument is resolved.
Yeah, exactly. The other question about compensation is that you can pay compensation in this particular instance by forgiving rent.
And that has to be done very carefully. You can't say, you can just do it without this amount of rent. No, this has to be done very carefully. It has to be done by agreement.
Yeah.
So that the tenant signs off, the landlord signs off, and that's considered compensation for that purpose.
Yeah, and there has to be agreement, and that actually, by the way, can also include unpaid rents. So forgiving of unpaid rents. Yeah,
so if somebody's a year behind in their rent and
a year behind in their rent, and they should be evicted for another reason.
You should have been evicted on an N4.
But if they were, let's say, they were a month behind, and it was something that happened. They said, "Okay, I couldn't pay September because
my dog died.
I got laid off for 6 weeks." But I picked up and paid in October again, no problem. Maybe at the point being is you might enter that as being an agreement that the non-payment of September was forgiven.
Yeah, that sometimes happens. Like I had one guy had to take his dog to the vet and had a huge vet bill as a result, and he was unable to pay the rent. And so he proved it. There was a vet bill and there was something serious going on, and he was able to resolve it by paying that. So we use that. It says, okay, just don't pay the rent, and we consider that compensation.
Yeah. So when we're talking about what a tenant should do there for an N12, that's the compensation part of it, which is an very important part, because with any of these notices, there must be compensation. Right?
Yeah, and the landlord has to follow everything down to the letter. If you don't give compensation, or if it's not notified or recognized as compensation by the tenant, this is going to be thrown out.
Yeah. And the one exception to that is that the email transfer was made to the tenant refused it.
Yeah, because some tenants try to send it back or they refuse it.
Yeah.
Okay, so just be very, very wary. So these are things, and that's an attempt to give the compensation. So what happens is the landlord did their part. The tenant can do nothing about it.
Well, that's the equivalent. Forgive me if I'm wrong. That's the equivalent, isn't it, of writing, me writing a check and saying, Angela, on the 1st of February, for $972 or whatever, and here's your check, Angela. Okay, and you then sending that check back to me, right?
Yep. Or ripping it up.
Yeah, exactly.
So these things like that, they can't be doing that. You cannot fight against that by doing that.
Yeah.
Okay, so what you do is you play on the facts, play on the case law. There's lots of case law out there, and the N12 has to be the proper form. Writing a letter to somebody, I've seen the letters written, where the landlord says, oh, my sister is moving from India and needs a place to stay, and therefore I need your apartment. So I need you to move in 60 days on such and such a day. Hey, so I just tell the tenant that's not going to happen.
Yeah, that sort of thing, because, and again, you end up educating that particular landlord when it comes to the hearing, and we say, and can we have a copy of the N12, please? Oh, you don't have one? Because this isn't a valid N12. This letter is not a valid N12. So your L2 application is founded on quicksand. Yeah. Bye-bye.
Yeah. And there's also a lot of times they don't have to give an N12, but they can imply an N12. For example, by sending you by text, he says, oh, we sold the house, the purchaser wants to move in. Yeah. So you're going to be out in 60 days. So the tenants say, oh my God, hey, they don't know their rights. They don't know anything. They didn't talk to anybody. So what they do is they pack up their bags and move. And then they move out. They find out all they did is re-rent it at a higher rate. Yes, they can bring a T5 action.
Yeah. And that actually brings up another one of these, and this applies for a tenant. This applies to both cases for the N12 and the N13. When the purchase date or when the sale date of that house occurs, so the house was sold on the 31st of, on the 27th of December 2024. So keep an eye on the property on the 28th of December, who moves in, right? If nobody moves in, just keep coming back there. Keep casual views.
On the door.
On the 4th of March.
Oh, hi. My name is Cindy. I used to move here. I was just kind of wondering. I think I might have left some of my stuff in the backyard. Hey, by the way, how long have you been living here?
Yeah, exactly. Those kinds of things. And hey, I had one which was kind of I had one which was interesting, because the person the person who's black said my parents are moving in from Nigeria, and we didn't believe it one bit. And 110 days later, a Polish guy moves in.
Oh, that was an interesting one.
He didn't look very much like their parents. Didn't look much like those parents from Africa.
Yeah, exactly. Like that family, the landlord's family is all black, and somebody who's white, perhaps, and maybe Eastern European. I don't think so.
No, didn't look a bit Nigerian.
Yeah.
But so we caught them at it, right? We caught them at it, right? And it happens. So as a landlord, if you're going to do this, if you're going to move your family in, move your family in. If you don't move your family in, make an offer to the tenant. Let me repeat that. If you do not move the member of your family in, either yourself, your spouse, your parents, or your children, for whatever reason, it doesn't matter.
Yeah, because things happen. Things happen. Maybe it doesn't work out. Maybe the job didn't work out that they're supposed to come down for. Or the son decided to go to Toronto for school instead of Brock University.
Exactly.
So these things happen. So let the tenant know.
Yeah, let the tenant know. Give them an offer to move back in, right?
Yeah, because otherwise they can do that, and they can take an awful lot of money out of you.
It can be, when you think about the consequences here are potentially a year's worth of rent for that new rental unit. So if this person was paying you $1,500 and now they're paying $3,126.97, that's 12 months times 3,196.27. Figure that one out. That's going to hurt.
Wow, that's a lot of money, Peter.
Yes.
Yeah,
exactly. Think about it.
And they can also be fined. If they're acting in a particularly egregious fashion, they can also be fined by the board.
Yes, they can. They can. You
Over and
have to go a
above.
long way. You have
Over
to go
and
a long
above
way
what
to
you
be
got to pay
fined.
the Senate. And
Yeah.
being fined by the board and then refusing to pay the fines, you can't bring any other applications to the board.
Yeah.
Stuck.
Well, that's the ultimate issue. But you have to go a long way to be fined.
Yeah,
Right?
I've seen that where they might give you a $200 fine.
Yeah.
And then you pay the $200 fine, everything's done.
Yeah. All right. So moving on, we've been talking about we're talking here about no fault evictions and the difference between the N12 and the N13. And we've been talking simply here about the N12 family buyer or carers moving in. Now the next one is an N13, which is a renovation. I love the renovation cases.
There's N13s can be used for renovation, demolition, or for conversion.
And the other thing is that repairing the kitchen sink or putting a new countertop in the kitchen, that doesn't cut it.
Or painting the walls, or decorating the lobby.
Yeah. All of those things do not cut it. You can move the tenant out into a hotel for a few weeks if you need to do sort of those types of renovations.
Yeah, like if you have to tear down the bathroom, for example.
Yeah.
Okay, and the tenant has to be somewhere else for a few days. Yeah. That's fine. Yeah. But the thing is, you have to be use common sense. Okay, you need to also have a permit.
Yeah.
Well, you cannot just go in there and do an N13 without a permit, and the permit has to be offered to the tenant.
Well, in fact, actually, so what should a landlord do in terms of an N13? And as you say, that is purely and simply about, they're restructuring the building. They're doing the whole building, and it is a large amount of work that's going to take at least a year to complete when it's all said and done. Mm-hmm. And if you are going to take less than a year, you have to give the unit back to the tenant. If you're taking more than a year, there you have to give the tenant the right of first refusal.
Yep, the right of first refusal. And on the tenant's part, if this is something you wish to exercise prior to the date of termination, you need to let your landlord know in writing that you wish to exercise your right of first refusal.
Yep.
And when when the day happens, you get moved back into your unit or a similar unit at the same rent you paid before you got skedaddled out.
Yeah. The other issue about that is that there can be a number of other things, which is we're changing the rental unit from a residential to a commercial, for example. We're changing the building so that it was office shops and offices on floors 1 and 2, and floors 3 and 4 we were residential. The problem here has been that's been detrimental to our commercial tenants. Now we're converting floors 3 and 4 to pure office space.
Yeah, like we just got a big company coming in and they want to take over the top 2 floors.
Yeah.
Right? And we're converting.
Yep. Yep. Okay, so there's there are very strict rules about an N13 renovation, right? And there's differences between a demolition and a renovation. Let's be very, very clear about what those are.
And the landlord-tenant board adjudicators sometimes disagree on what the differences are.
That's true as well.
Because remember we put forward for demolition because we were changing the number of bedrooms and the structure of the units, and then they refused to consider that a demolition, even though other court cases have said that that was a demolition, because those units that were there before were no longer units.
Yeah, in fact, actually, that was one point we put forward, the concept that apartment D was changing from a 3-bedroom unit to becoming apartment 4, which was a 2-bedroom unit.
Yeah.
Right, and the adjudicator said no, that was substantially the same unit as before.
Yeah, exactly. That was their opinion. They expressed it, and unfortunately, you could take that to divisional court because that is a question of law. If you wanted to challenge that, that would be the rule of judicial review.
Yeah.
Okay, but in that situation, this was a mess. This particular landlord question was trying to create more units on the same floor, so they have more different affordable units.
And what they were doing was moving, scaling down from 3-bedroom units to two-bedroom and 3-bedroom units to 1-bedroom and 2-bedroom units. Is what we're trying to do.
Yeah,
and
because a lot of them were singles renting it.
It was an interesting approach, but and even with all of the stuff that we put in on that particular package, and the landlord did a lot of work in that particular package, and at the end of the day, the landlord and tenant board unfortunately said no.
Nope, right? They said no, and basically that's what they have. And I said the only challenge to that is to a judicial review, if the landlord would have chosen that, but at this point he didn't.
Yeah.
Hey, I mean, there's a lot of reasons why the adjudicators would choose that, and they have to give reasons in their explanation and in their decisions. They have to give reasons why they disagree with the legal representatives when they're making arguments. Yeah. Even if we threw 17 different case laws at them from the Supreme Court of Canada and so forth, some of them will ignore a Supreme Court of Canada decision and go along with another adjudicator's decision. Okay. And it's called the Statutory Powers and Procedures Act. They have the authority to run their tribunal in a way that is most efficient and the best way to produce the best result in terms of justice.
Okay, so one important thing to remember about a renovation is that this N13, until you actually, if you manage to get the tenants move out, you're fine. You can move ahead with the renovations you need to do. If you don't manage to get the tenants to move out, then you can't do anything, and your building permit is theoretical until you can get an empty floor space. But the other question is,
and it costs money to extend it.
Yeah, and actually, the other question there is that you could negotiate. There's potential you could negotiate a way out for the tenants.
Yeah,
exactly. In fact, often recommended that you do.
Yeah. In a case with a demolition, which was very interesting, they were putting in an $88 million housing project in Niagara Falls. And there were 5 units. There were 3 tenants remaining in 3 units, and the other 2 people have moved out cooperatively. So I managed to get 2 of them out of the 3 units using the N13s and for demolition permit. And eventually we bought one of them out and the other one just moved. But then at the end of the day, there was one person who was telling the board that he actually owned that property and that these people were somehow committing a fraud on the city of Niagara Falls, and that he wanted to get the RCMP involved, everything else. I just had to calmly go about asking him, do you have a copy of the deed that has your name on this? Hey, do you have a copy of any transfer or any agreement that you've had with the prior landlord? Hey, all of this stuff I had to be very calm and ask, like rather than just say, you silly thing, but at the end of the day, the adjudicator got what I was saying. And she says, I don't think so. Hey, then she sent the letter back. She says, you're out. The guy reviewed the decision. He had the nerve to review the decision. And in the meantime, he was holding up this $88 million housing project, this one individual with so much power. Okay? And it cost my client a ton of money, not only in my legal fees, but also in money that he had to pay to the city to keep that demolition permit going and to build the new unit.
And
And this
probably,
is hundreds of pages, this permit. Like,
and
this is where,
probably,
yeah,
and probably with that, when they eventually, the building crews got involved, the building crews are now working overtime to catch up with the deadlines that have been
and
imposed
these
upon
all have their own deadlines built within them, and they have to have an order of trades and so
Yeah.
forth. Like, it's absolutely crazy, you know.
Yeah.
And the thing is, but one person like that wants to hold it all up because they want to see how far they can fight it. And I remember that. Then at the end of the day, he wrote a nice little thing. I think he wrote me a letter or something about how I represent mafiosa type people.
Oh no.
Yeah, and that my
Was,
people are from a crime family or something. And no,
was
they are.
that your
They're just
first
developers from Toronto. I mean, who cares? I mean, they're trying to do what they do for a living, and who cares?
was that your first death threat, Angela?
Oh no, I've had several.
Okay.
You
We've been
get those as a legal professional. You get those.
okay. We've been discussing here what a landlord should do for an N13 renovation.
And you have to be very careful. You have to be even more careful. You have to be very clear about what renovations you're doing.
Yeah.
You have to have the permits already in place or applied for. You have to have a lot of stuff in place. And you have to give a lot more notice to your tenant than you do for an N12.
Yeah. Because you've got to give 120 days and 3 months worth of rent.
Yeah, exactly. Well, 3 months worth of rent if it's more than 5 units. If it's less, then it's a month worth.
Yeah.
Okay? And you also have to offer the right to take the unit back to the tenant. All of these things have to be spelled out, and that's why you need to use the N13 form. And then it has a little check-off space where you're checking off what you're doing and why you're doing it, and what you're doing exactly. And if you're converting it, what you're converting it to, and what your permits are. Okay, so if you have a permit for commercial, like you're rezoning it or something, then you have to show the rezoning application. There's a lot of things you have to do with these things. You know, you can't just go in there and says, I'm just going to make this into my office. Why? Because I feel like it, and I'm going to take over this building and get into my office.
That actually is actually part and parcel of that. When one of the cases I was observing one day in a hearing block that I was in, the paralegal in question was saying, well, why are we making these? Why are we turning apartment 1 into offices and offices, storage and bike parking space? Why not apartment 2 or apartment 16 or apartment 72 come to that?
Yeah.
Right.
Yeah. Like at the end of the day, the property owner can do what they want with their property, but follow the correct steps.
Yeah.
Okay? 9 times out of 10, when somebody shows up at this office, it's either a tenant or a landlord. Somebody did not follow the correct steps. Somebody made a mistake on the way.
Yeah.
And
that is, of course, when there's disappointment within the landlord and tenant board, isn't there?
Yes, it is. I've seen it a lot of times. I've seen a series of disappointments with N12s, for example, where they were all tossed out because of technicalities, because of something or other. Right? And landlord after landlord started throwing a fit. Now I have to wait 8 months or 10 months to get my tenant out. Oh my God. You know, they're going on and on. I can't do anything for you, Mr. Whatever, Mr. Jones or whatever.
You should have gotten your application right in the first place.
Maybe you can get it done next time.
Yeah.
So I mean, this is what happens.
Okay, so when talking about N13 renovations here, so what should a tenant do? Right?
Yeah, tenant should inquire. Get a copy of the permit. Get a copy of all the stuff that they're doing, and ask questions.
In fact, actually, one of the things that should come with the N13 is actually a number of information. If they've given you prior N13s, or if they've given prior N13s to people in your complex, they need to be declaring that.
Or even what they own elsewhere within the last 2 years.
Yeah. All right.
I've
So those
got a few of them on that.
Yeah. Okay. The other question that a tenant should be asking, and the fact that all it needs to be within their N13 application. So the other thing that they need to get is compensation. Right. The compensation check should be, again, as I said, should be paid independent of your rent.
Paying your rent each month until your last month rent. Then the landlord cuts you a check for the 3 months.
But the other thing is that the compensation check must be paid by the date, by the termination date that is on the N13.
Yeah, exactly. Because if it's 1 day late or $1 short, it's tossed.
It's gone. Yeah.
Yeah.
And in fact, actually, that was exactly what happened in one of those instances that I was representing the tenant, and the landlord paid, the termination date.
One of them.
Pardon me?
Kept making error after error 3 times in a row. Same landlord, same tenant.
That was a different one. The termination date that I had was 31st of May, and the check arrived on the 1st of June. Right?
Yeah.
So we've got we put up in the on the evidence block, check for the 1st of June. Termination date for the 31st of May. Preliminary matter and tossed. Sorry, gone.
It gets tossed, and you have to be careful with that.
Yeah.
So this is why I suggest, if you want to do this or you need to do this with your building, remember you do have a right to do what you need to do with your residential or other buildings that you own, but take the right steps. Get legal advice. Come in here, tell us what you want to do with the building, and we'll work with you to make sure you're doing it right and that you don't get it tossed.
Yeah.
I've seen a guy walk in here the other day. He had his own N13s. The wrong dates were put on it. And he says, "Why, what's wrong with it?" I said, "It's going to be tossed." And I explained to him why it was going to be tossed. Okay. And I said, "We need to get this done ASAP. Okay. So that we're not going to lose too much time." So now we're reworking it.
And the other thing, of course, about N13s is that they must have detail. They must detail what, the why, the where, the when, the how, the who, the everything, right?
Did you ever get one when they had a permit, but the permit didn't apply to that person's unit? I did.
You had one like that?
Yep. I remember I asked a gentleman on the other side who was representing the landlord, and I asked him, I said, "I need the permit that specifically applies for this unit." Okay. So he went and sent me a permit. Everything was done. And I looked at it and I said, this is for the basement. Okay. And my tenant looked at that and says, "No, that's not my unit. It is not even laid out like my unit." So I said, okay. So I just said, okay, so I sent the letter back to the other side, and I said, "Well, my tenant's staying. Thank you." I think the person still lives there, I think. Meanwhile, all the units around her have all been renovated, and they're all twice the rent, but she pays lower rent. And it's probably driving the landlord crazy.
Yeah. And so it's an interesting thing is because all the elements of the detail must be in that application. We talked in the N12 about there needing to be a declaration. Well, a declaration in terms of an N12 is, by comparison to an N13, an N12's declaration is loosey-goosey, right?
Yeah.
You're kind of saying, I on the 1st of May, I intend to, right? No, when it comes to an N13,
if I'm drafting an N12 declaration, I make sure I put good details in it, and I tell you what to say, so that it ensures what is truthful, what you're trying to do, and it reflects why you have to move to that unit, even especially if you own other units.
Yeah,
because there's a lot of problems.
N13, I've seen the LTB give on less well-defined declarations.
I know. Again, the LTB doesn't always follow the same pattern.
Yeah.
Okay.
And I've seen them give on no declarations at all.
Yeah, which, and that could be reviewed.
Yeah.
I think you have to have a declaration, and the declaration should be something that states that is true, So if I give a declaration that I'm going to be moving in there and I'm going to stay at least a year, and then I don't, that just confirms the T5 application that's going to follow, right? And it's going to cost me a whole lot of money.
Yeah. Yeah. And the other question now is, when you're looking at an N13, when you're dealing with N13s, must, and I will repeat that, MUST, must have all of the associated paperwork going with them. Now, that's not to say that you've got the actual building permit, but you have the building permit application form.
Yeah, permit application, possibly the drawings, that sort of thing, just to help you with it. Hey, as much as you can, that's like within reasonable, so that they know what you're doing.
Yeah, and states in positive terms that the apartment 12B will be knocked down and will
brought down to the studs.
Yeah, as will apartment 13, 13A and B, and that these will now form 4 one-bedroom units, or whatever the.
And this is what our intent will be, and what will be rebuilt. And the rebuilt units, if the tenant wishes to move back into a rebuilt unit, they can exercise their first right of refusal.
Yeah, and exactly. So all of those things must be detailed very precisely. And what I was trying to say is that I've seen N12 cases whereby there's been no declaration, and they've granted it in favor of the landlord and the person moving in. Whereas with an N13 application, if you do not have any documentation, it will never be granted.
Yeah, they're going to look at you and go, "What's this?"
Yeah, exactly. Your piece of paper that has all the N13 details on it, that has a box that states what you are going to do, right?
Yep.
That box,
they want to know why the tenant cannot stay while the renovations are being made.
Yeah.
Okay? Because these renovations have to be pretty intense. They will not be able to use the kitchen for a month. They will not be able to use the bathroom for 2 months. Yeah. Because we're going down to the studs and we're replacing everything.
Yeah. And that box has
everything, the wiring.
Yeah. Full and detailed, right?
Yep. And that way you have to put that in details. And yes, many times you got to do it. I mean, a lot of these buildings are old, and you got to make them new.
And putting nothing in there is not an option.
Yeah, exactly.
Be very, very clear. Putting nothing in your N13 in the details of the things that are going to go on, that is not an option.
Yeah, don't just say we're renovating the whole first floor, the tenant has to move out. Don't say that either. Yeah. You have to say why. Why does the tenant have to move?
And to your point about the building permit, if apartment 4 is not included in the building permit, it says the building permit applies to apartments 5 to 12.
Yep. Exactly. Building 4 is maybe you did apartment 1 to 4 last year.
Yeah.
Okay. So these are things that have to be noted and included.
Yeah, they all have to be full and detailed, and that's what's the important thing. So,
you ever wonder why nobody wants to be a landlord anymore?
With those kind of level of details, yes. So that's what a landlord has to do, is make sure they put all the detail in. What the tenant has to do is, probably, if you're given an N13, go find a legal person.
Yeah, go find a legal representative. We know what to look for.
Yeah. And, and basically,
we can also ask the landlord the correct questions. And if they have a legal representative, the legal representative the right questions.
and we're more likely to get to the bottom of it. And
Mhm.
often one or two questions that we ask can drive things in the right direction, can often get a solution, and may even
You get a resolution to it, or we'll confuse things in such a way that the landlord is not going to be able to get his way at the hearing.
and there's two options there when it comes down to what the tenant's options are. One of those options is what's called cash for keys. Landlord and Tenant Board doesn't know what cash for keys is. They don't recognize cash for keys.
And it's not in the law. It's not in the act.
Yeah, it's
It's
not
just
in
a
the act.
settlement.
Yeah.
It's like
it's a
you
private
get fired from a job and you get offered severance. You get a package. Nobody says you have to give a package, right? Other than their severance entitlement minimums.
Yep.
Right? But you can give more, or you can add other things to it. There's a lot of things that are negotiated.
Well, like things like benefits might be, for example, included in that type of
Yeah, exactly.
Here, basically, a lot of this relates to, and that applies to both N12s. So cash for key deals can apply to N12s or to N13s.
Mm-hmm.
Right.
We've had significant ones where I've negotiated up to $50,000 for a tenant.
Yeah. And by the way, if you've got an N12 and you believe that it's in bad faith and you negotiate a cash for keys deal, you're not going to be going back to check whether the bogus person is moving in there.
Yeah, if you think that there's anything bogus, anything at all, come to us. Even if you want to negotiate a cash for keys, talk to us first.
Yeah. Yeah.
Right? Because we don't want you to end up in a situation where, if it is bogus, we want to protect your rights.
Yeah, exactly.
Right? And we have to give you your options because there's many different options.
And at the end of the day, if you negotiate at if you're at an N12 hearing, or if you're at an N13 hearing, and you opt for mediation, a mediator could actually give options as well.
Yep, exactly. Even though I haven't seen too many mediators in those rooms.
Yeah. Typically, though, those mediations don't result in the same amounts as could be gotten for a cash for keys deal. And to a large extent, when it comes to cash for keys, a lot of it depends more upon the question to the landlord about how urgently do you need the property.
Yeah, that's what I said. That's what I say. It says, how much is this worth to you?
Yeah. Yeah. And typically, yes, I need this unit by the end of February. The price goes up, right?
Yeah, everything just goes up.
Yeah. If it's like, well, they can stay there till the end of August.
Yeah.
Maybe the price is only a month's worth of rent.
Because a lot of times you talk to our clients. Sometimes they just need more time to get out of there. Yeah. Maybe they're intending to move. Actually, they just didn't want to rush out the door so fast. Maybe they wanted to wait till the end of a school year or something.
Yeah, exactly. That was exactly the case that I had. His child was going to a gifted school. He wanted to the end of the school year. And that was how the negotiation was. There was no money involved in it. It was like, can we keep it till July, the end of July? School year's done in June. Gives them then they get to the end of the school year in June, when the child is not disturbed in their studies, then they can move out during July.
Yeah. So there's lots of reasons. There's lots of different interests. We have to look at what I call a best interest principle when I negotiate. Yeah. Because it's not always who could get the highest amount of cash for keys.
No,
it's not always about money. It's not always about money.
Yeah. It's not always about cash. Exactly that. And that was the deal. It was like, I just need it till July. Not I don't want to be moved out in May. I want to be done in July.
Yeah.
And the landlord said,
things you need to think about. Talk to us. What is it that you want? What are the most important issues that you want us to look at when we get into negotiations or discussions?
And
right?
and the landlord in that particular one, when he said, I just need it for the end of July, and the landlord's going, oh, is that all?
Yeah. I've never had a tenant come into my office and say, I want to bankrupt the landlord and I want to make him homeless. I've
No,
never had that.
at that point, they're almost shaking hands, aren't they? You know?
Yeah, I've never had that, right?
Yeah.
But I always asked them, I said, what is your interest? Right?
Yeah.
And it's usually something we can work with.
Yeah.
And the landlord is okay. Eventually we find a common ground. Sometimes it's more difficult than others, but we can find a common ground.
And remember this, actually, for a tenant should remember this. If you're a tenant, there is absolutely no such thing as a tenancy for life.
Yeah. Yeah, that's different than a life lease.
Yeah, that's
There
different.
is such thing as a life lease, but that's different. That's a different thing than under the RTA.
Yeah, but the RTA doesn't manage life leases.
These are registered on title and blah, blah, blah.
Exactly. Yeah. And typically they are like brothers and sisters of the deceased owner of the property, or somebody who was living there anyway.
Yeah.
So it's a that is an ownership thing, not a residential tenancy thing anyway.
Yeah, like I've had somebody who sold a life lease to a property and then they got them kicked out, and then all of a sudden, well, we're going to go back and get the money that paid for the life lease back. Things like that end up in courts. Not at the tenant board, but in the regular court.
Handled by the landlord and tenant board. Yeah. No, not in any way. Okay. So
all right, so this was a heavy session.
I hope you've learned a thing or three about these no fault eviction situations, and what the difference is between an N12, which is for personal use, and an N13, which is for renovations. And if you've got any questions or you need some advice, you're quite welcome to contact Invictus Legal on 905-688-5598, or email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal. Or why don't you just email the both of us? That would be
nice. That always works out well, because I usually give it to Peter's attention. Said, Peter, did you get this?
Yeah. Or you could go
work on it and file a response. I usually send a letter to them and I said, okay, when can we call you?
Yeah.
So we try to get people in here. We try to talk to them. We try to answer people's questions the best we can. And we certainly welcome your input. And for those of you watching, if there's another topic you'd like us to talk about, anything that's within the legal world, that could be commented upon or in the public interest type of way in the legal world, just ask us, and maybe you'll figure out a way to do it. Or if you can think of a special guest you might like to see, or a type of guest you might like to see on the show, we'll certainly endeavor to.
I know a guest I want to see on this show.
Oh yes, I know.
I want to also remind you that our website is https weareinvictus.legal.
Yeah.
And so now this leads us to Angela's favorite part of the show.
Oh yeah. So what you heard today on Spin Legal, whether it's on this show or in others in the 51-part series so far, is not legal advice. If you need legal advice, then please contact a paralegal or a lawyer. I'd love you to contact us. You probably could. And if it's not in our purview, we can tell you who you should be talking to. Or you can contact someone else you may know if necessary. Okay? Thank you.
And if it's your third cousin twice removed, probably you shouldn't be speaking to them.
Yeah.
Not unless you can actually see the license on their the license paperwork that says, hey, they've got a license in there.
An LSO number.
Yeah, they got an LSO number, etc.
Mm-hmm.
All right, that's kind of a little bit of advice stuck on at the end there. All right. Okay, so thank you for watching and have a great day. And next week we'll be having episode number 52. And if you've got something you want to suggest we talk about, we'll talk about it.
Yep, just throw it on the comments section or write us an email, whatever you wish us to speak about, we'll consider.
Yeah. And thank you very much. Have a great